Yeah. Well, that's good. You know, to go to
All right, Greg, if you can hear me, we're okay, or we're ready to go here in the room. I'm assuming you're ready.
Okay. Yes. Can you hear me?
We can.
Okay. Then we will get started. I heard that the recording has started, so we will go on the record now. My name is Greg Frank. I'll talk just ever so briefly about myself a little later. The time is 6 o'clock, or really close to it, on February 27th, 2024. And this is the time and the place for the hearing for Deschutes County file numbers 247-22-00436-ZC and 247-22-00443-PA. And I'm not sure, and I'll have Ms. House clarify for me on the staff report. It included a additional number, and she can clarify for that me shortly. As I indicated, my name is Greg Frank, and I'm a hearings officer in this matter. Before we turn to the particulars of this hearing this evening, I would like to turn things over to Ms. House, who is a staff planner, and she's going to describe how the economic process works. And after she's completed with her comments, I will come back and have a few additional comments on my own. So, Ms. House, the floor is yours.
Thank you. For the record, my name is Caroline House, and I'm a senior planner with the Deschutes County Planning Division. As Hearings Officer Frank just mentioned, tonight's hearing is for a plan amendment and zone change request. And there is a modification that was filed by the applicant, and that's not noted on my screen, but I can state that number for the record in a few minutes if that's necessary. Okay. So I'll begin the hearing by going over the format of the hearing and how you can testify if you'd like to tonight. I'll then present a brief staff report. We'll then move on to the testimony portion of the hearing. The applicant will present first and we'll have 30 minutes. Then persons in support will have 3 minutes. Then anyone in opposition will also have 3 minutes. And anyone neutral to the request will go last. Following that, the applicant will have 10 minutes for rebuttal. And lastly, if staff has any closing comments, that will happen at the end. And I do want to note that the hearings officer can eliminate or modify these time limits at any time. So we do have some in-person attendees tonight. If you're attending in person, I'll go over those instructions in a second, but we are hosting a hybrid hearing tonight where both in-person and remote participation is allowed. For anyone testifying, please state your first and last name and provide your mailing address before providing your testimony. So Hearings Officer Frank will call up our in-person participants for testimony. Please come up to the table so the audio can be picked up on the microphone. And if you haven't already, please make sure you've added your name to the sign-in sheet that's on the table by the door. If you're testifying remotely, you need to be logged in using Zoom in order to testify. Hearings Officer Frank will ask you to use the raise hand feature to notify us that you would like to testify. If you're on a computer or smartphone, you will need to click the raise hand button. That's usually in the bottom center portion of your screen. And if you've dialed in, you'll need to dial *9 on your keypad to activate the same feature. In addition to oral testimony tonight, anyone can submit written testimony. Please submit that to me if you're attending in person, if you haven't already provided it to me. And if you're attending remotely, you'll need to email that to me. My email's on the screen. It's caroline.house@deschutes.org. And please be sure to submit that to me before the end of the hearing. If the record's not left open, anything received after the close of the hearing may not be considered by the hearings officer. Hearings Officer Frank and staff are responsible for an orderly and respectful hearing. Anyone being disruptive may be asked to leave. And I'm going to pause now and ask if there are any objections to the hearing format that I just described. If you're attending remotely, please use the raise hand feature. All right, no objections. So I'm going to turn it back over to Hearings Officer Frank for his hearing instructions.
Thank you, Ms. House. I appreciate it. As Ms. House described, we are following a normal hearing procedures that are set forth in the county code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I'd ask for your patience. because we want to make sure we get through each of the steps that Ms. House just outlined. The application is being considered through what's called a quasi-judicial process. It sounds fancy, it isn't so much. You're going to get an opportunity to say what you want. And that to me is the most important part. I will consider only the factual evidence that is in the record, which will come through either the testimony or written submission into the record if it's done so timely. I will then apply the facts that are in the record to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and the applicable criteria relevant to this particular hearing were identified in the public notice announcing the hearing, and they were also set forth in the staff report, which is also available to you electronically. And I'm not sure if Ms. House has any in the hearing room. The public notice and staff report are posted on the county's website, and they are also hopefully available from staff upon request. It is important that you direct all your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you also to explain why that particular criterion that you're suggesting must apply, and to do so with specificity so that other participants may respond and so that I can address that issue in my decision or recommendation. The failure to raise an issue with enough detail to enable me or other participants to respond may preclude your ability to appeal that issue to the Oregon Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed condition of approval with enough detail to allow me to respond to the issue in my decision may well preclude an action for damages in circuit court. As I just noted, I serve as a county hearings officer in this matter, been assigned this particular case. I have a contract with Deschutes County to conduct impartially and objectively land use hearings such as this one. It's my role, my job, to be a neutral decision maker. Thus, while I may have the contract with the county, I'm obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I will state for the record that I do not have any personal, social, business, or financial relationship with the applicant or anyone associated with the applicant, and I'm not aware that I have any such relationships or connections with any other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff, but only to discuss the particulars to today's hearing and not the substance of the application. For example, things that I would talk with staff about are scheduling and making sure that I receive the relevant documents, or at least access to the relevant documents in the case. I do not have any ex parte contacts to disclose, and it is my obligation to preside over this hearing in an efficient manner. Before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? If you do, would you do me a favor? If you're online, would you hit the raise hand function? And if you're in person, raise your hand and let Ms. House know. So I will turn it over to Ms. House. Is anybody raising their hand in any way, shape, or form, physically or online?
No.
Thank you. The last thing I have is that I want to make sure we have a very clear understanding of this. The record will close at the end of the hearing tonight, unless, all right? And it's a big unless, and I'd like you to understand what that means. So the record will close unless someone during the hearing asks me to keep the record open. What that would mean is that I would allow additional time for the submission of written documentation. So if you wish that the record remain open beyond tonight, then during your testimony or prior to the completion of all testimony, That includes both for, against, and opposition and rebuttal. Would you please, during your testimony, let me know or let Ms. House know that you wish the record to remain open? If there is such a request, and it only has to be made one time, it's like ring a bell, you only have to ring it once, it's been heard. But once the request for the record to remain open has been made, then it will remain open. The time periods and the due dates and the logistics of all of the open record period stuff will be talked about by Ms. House at the conclusion of the hearing if someone makes such a request. So we'll talk about that at the end. I'm just cautioning you that if you want the record to remain open, then you have to ask. I won't remind you again. All right. Then with that, I'm going to turn it back over to Ms. House. She is going to give the staff presentation or summarize the staff report. Following that, I will turn it over to the applicant or applicant's representatives. I would remind you that when you first come up to testify, if you do us all a favor and give us your first name and last name, it always is a huge assistance to me if you do it slowly and spell your first name and last name, always appreciated by me. And would you also give a mailing address where a copy of a decision or any other correspondence may be sent? So with that, Ms. House, I'm going to turn it back over to you.
Okay, so I just have a few slides for tonight's staff presentation. So just starting out with the subject property is located at 19775 Destiny Court. This property is just north of the City of Bend's urban growth boundary, and the property is currently 65.1 acres in size. And that's reflective of a recent property line adjustment that's been perfected. And the tax assessor maps now currently show that configuration of the property, and that's the map that's on my screen reflects that property line adjustment. So the applicant has requested a comprehensive plan amendment to change the designation of the property from agricultural to rural residential exception area. And the applicant has also applied for a corresponding zone change to rezone the property from exclusive farm use to multiple use agricultural. And the applicant is not requesting a Goal 3 exception as part of this application. The applicant is arguing that the subject property does not constitute agricultural land. The staff report generally found that the applicant had provided responses addressing the applicable criteria, but there were a few potential issue areas that staff is asking the hearings officer to focus his review. The first is compliance with statewide planning Goal 5, specific to protected scenic resources and mining resources. Additionally, staff is asking the hearings officer to confirm compliance with OAR 660-033-0020, the definition for agricultural land. The applicant has responses to some of the subsections of that administrative rule, but other sections, not as much information. So again, staff is just asking the hearings officer to review those standards. All of the materials in the record are presented at the following website that is on the screen right now. So that includes the staff report, application materials, supplemental materials, and public comments. I do want to note, since I think 4 o'clock-ish today, I received supplemental materials from the applicant, and I did receive public comments from Central Oregon Land Watch as well. I confirmed they actually are published now, but I'm imagining most people have not had time to review those, but I do want to acknowledge receipt of those just prior to the start of tonight's hearing. And I guess the only other thing I want to mention, that modification number, just for the record, is 247-23-000-651-MA. And the applicant did file that modification to reflect the property line adjustment, reconfigured parcel configuration, and have that be reflective in this particular request and a subsequent request that's not part of tonight's hearing related to a planned unit development that's also pending. But again, that's not part of tonight's hearing. And hearings officer Frank, I'm available for questions now.
Thank you, Ms. House. I have none at this point in time. I'm going to make one additional disclosure since Ms. House indicated what items had been submitted into the record. I in fact reviewed the public record about half hour ago, I guess it was. And I make copies of everything that I have. I know it's not good for trees, but I do it because I want to read everything that people submit. And the last item that I showed on the list of public documents was a submission dated February 27th, 2024 from Central Oregon Land Watch. I also reviewed everything else that was submitted prior to that. Let me tell you what that means when I said I've reviewed it. I in fact just reviewed it. I didn't read it carefully. I didn't assimilate most of the information in there because I don't want to be making a decision before I hear all of your testimony and whatever you have to submit into the record as well. But I want you to be aware of it. If you have a document that you wish me to refer to during the hearing, off to that side, the left side for me, I have my computer screen open and I can open up your document and take a look at it as you discuss it. So I just want you to be aware of that. This is then the time and the place for the applicant for testimony. So are they in person, Ms. House, or are they remote?
The applicant and their representatives are all attending remotely. So we're going to go ahead and promote the applicant and their attorney. And then I'll defer to both of them on whether they want to elevate any of the other professionals they have on their team in attendance tonight.
Thank you, ma'am.
Good evening. Can you hear me?
We can hear you loud and clear.
All right.
I can, at least I can.
Can you see me?
Well, I can now.
Okay, good.
It was a dark black screen, and now all of a sudden, there you are.
Well,
All right.
I was just elevated to panelist. I had no control.
Well, I know how you feel.
Good evening. My name is Liz Dixon. I am a land use attorney here in the city of Bend with the law firm of Dixon Hatfield at 400 Southwest Bluff Drive, Suite 240, Bend, Oregon 97702. I am here tonight representing Destiny Court Properties, LLC, which is member managed by Ron Cochran and Julia Kennedy Cochran. And I believe that Ron is with us tonight remotely. I also have with us tonight a couple of consultants that I think may be able to be helpful. One of them is a gentleman by the name of Tim Weishaupt. He is the managing person with Sun Country Engineering who has prepared the tentative plans and a lot of the analysis that you see throughout the extensive exhibits that we have in front of us on this case. And he has been helping me with this since 2017, if you can believe it. Another one involved in this is Joe Bessman with Transite Consulting. Joe has done the transportation analysis for us and is available to answer any questions that you may have as well. With that said, I would like to request that the record remain open. My preference is that this initial phase be open for 2 weeks. And the reason for that is because we had a recent change in the law that came down from the Court of Appeals on January 24th, which has a significant effect on the definition of agricultural lands as it relates to Eden Acres, 710 properties. And we are still in the process of figuring out the best way to comply with those new rules. And so we would like 2 weeks of completely open record before 1 week of responsive record and 1 week of final argument. Okay. There are a number of clerical things that I need to get out of the way first. And they seem nitpicky, but when you leave things in staff reports that are wrong, they can get duplicated, and we want to avoid that. In this case, Caroline has done an exceptional job of tracking myriad changes. But where we are now in this evolving project is that there are a couple of things that need to be straightened out. The first one, and these are all I'm going to reference directly to page numbers in the staff report to make it easy to find. On page 2 of the staff report, Caroline looks at the site description. And in her staff report, she says the area is 65.1 acres. Dial, however, the county's real property database says it's 64.92 acres. And the deed that I entered into the record as Exhibit 36 with Caroline this afternoon, and I believe Hearings Officer Frank has reviewed, says that it's 65.11 acres. So we have 64.92 on Dial, 65.1 on the staff report, and 65.11 on the deed. For purposes of this discussion tonight, I'm going to call it approximately 65 acres and hope everyone's okay with that. But I want to make sure going forward that there's no question about the area that we're talking about here. And my preference is that we rely on Tim Weishaupt deed because that's actually surveyed. And that's at 65.11 acres. The second clerical issue that I would like to raise is on page 4. It's regarding soils. This is a little bit more technical. The soils and study area in the staff report talks about Exhibit 3 referencing approximately 63 acres of soil analysis. It's important to note, and she discusses later on in the staff report, that an area in the northeast corner was left off, but she doesn't think it really matters. I think it's important to note, first of all, that there was a property line adjustment done, and that's 247-230-000-653-LL, and that removed 4 acres out of the northeast corner of the property. If you take a look at the map that is in the back of the staff report, you can see that the configuration of the property has changed. And part of the reason for that is because that property is not available for any development whatsoever because it is literally a ravine. And it goes down into the canyon that the river has carved so steeply that you can't climb down it. So when Brian contacted me to do the soils report, and he looked at the site, the first thing he said was, "What do you want me to do about that ravine? I can't even get there. I can't take samples. I can't deal with it. What do you want me to do?" I said, "Well, if you can't take samples, don't do it. Well, if anybody wants to look at it and say they think that's farmable, we'll deal with that when we get to it." So where we are at this point is that's been carved away and taken out. But his survey of approximately 63 acres, keeping in mind we're talking about a total of 65, still includes some of that ravine space down on the southern side of the ravine. But that's why that discrepancy is there. And I wanted to make sure that that was a little bit more clear than it already was. On page 7, the road department made a comment with regard to the interior private road system. And what Cody Smith said in his comment was that there was a bit of a discrepancy between our site traffic report, which talked about a dedicated public access easement, and the Deschutes County Code and State Code, which talks about public right-of-way. And what he said in his comments was he wants to make sure that we understand that we're going to be required to do a public right-of-way dedication. And that what it will be is public internal roads built to private road standards. And we concur with that. And I want to go on the record saying that we agree. I think it's largely semantics, but the important thing to note is Cody raised the issue. We're addressing it here. We concur. The next clerical correction is all the way down on page 35. It is in line 1 of the response. And what is said in the response is the 2 western lots of this proposal, tax lots 100 and 101, border and reach to the center line of the Deschutes River. That was true once, but it's not true anymore. So now that we've had the property line adjustment, now, first of all, it's all tax lot 100, and 400 acres has been sold to tax lot 200 to the west. So only a small segment in the southwest corner actually reaches the river. if you take a look at the staff report map, which is the last page on the staff report, you will see that only at the very southwest edge does the subject property reach the river. The rest of it is now separated from it. For that reason, I would suggest that the line 1 response be modified to strike the reference to 101 and the fact that it borders and reaches to the center line of the Deschutes River, implying that it does so all the way along. It does not. On page 36, on the last line of the response, a reference is made to 1.75 acre lots. That again is part of the property line adjustment change we made and the need to reconfigure the lots accordingly to keep the open space and scale. And those are now 1.70 acre lots, not 1.75. And I want to make sure that no one is misled by that statement. And the last one, on page 39, there is a discussion of the very sticky subject that we're dealing with tonight, which is the question of soil types and what is ag land. This specific location is a discussion of OAR 660-033-0020A, and it is the burden of proof that I presented. It's indented on the page. Paragraph 5 of that, at line 2, references the soil types are predominantly class 1 and 8. That's a big error. That should be class 7 and 8. Class 1 is the best soil you can get in Oregon. Class 7 is not. It's important that that doesn't read 1 and 8. It reads 7 and 8. And we would ask that it be considered in that regard. Okay. The issues before us tonight, as with any plan amendment zone change, are complex and they are lengthy and they are the subject of much discussion over time. What I am going to do in the remaining 20 minutes that I have is not focus on the little stuff, because I think it's been covered really well by Caroline and in the 3 burdens of proof that we've submitted on this matter in addition to the modification. So what I'm going to talk about tonight are goal 3 and goal 5, because I think that's the essence of where we are in this application. I'm pretty comfortable with the rest of it. Let's start with goal 3. Goal 3 is one of the 2 statewide planning goals that are potentially problematic for this plan amendment zone change, because we have to show that we comply with goal 3. In order to do that, we have to show that we are not agricultural land, because that goal 3's purpose is to preserve and maintain agricultural land. So if this were agricultural land, a plan amendment zone change wouldn't be appropriate, and it wouldn't be appropriate to go forward. So what we need to be able to document is that this is not agricultural land. OAR 660-033-0020 and the statewide planning goal itself go through some pretty extensive definitions of how you get there. And I'm just going to walk through them line by line, because I think that's the easiest way to do it. In tandem with it, I'm going to ask you to keep an eye on Exhibit 37, which I submitted tonight, which is probably a somewhat novel use of what the county normally provides as a non-farm dwelling packet. But in this case, Exhibit 37 contains, I think, all the information we need to learn about what is and isn't agricultural land in the region. And so I'm going to be making a lot of references to Exhibit 37. Specifically, when you take a look at agricultural lands, it's real important that you, excuse me, phone. It's real important to look at the different classifications. The first one is soils, and agricultural land is defined first under Oregon code by classification of soils. And in the eastern part of the state, on this side of the mountains, if you're in soils 1 through 6, that soil is considered good enough to farm. The application that you have in front of you, as bolstered by Exhibit 3, the Site-Specific Soil Survey, and the DLCD's Soil Assessment Completeness Review as Exhibit 24, both show that this land is not significantly Class 1 through 6. As a matter of fact, it's 2/3 7 and 8. So it's really nasty soil. And if you take a look at the map that's attached to the back of the staff report, we included topography lines, and we did so to give the viewer a better sense of what that property looks like. There is very little flat surface on that entire 65-acre parcel. There are places where the rocks jut up 40 and 50 feet. There are places where it has ravines. It is not flat soil, and it is not loamy organic soil. It's rock. It's different sizes of rock. There are small ones and big ones, but it's just rock. So the agricultural land definition does not match the soils on the property. And that's, I think, the most important threshold to get over. We then get into the less objective standards, the ones that are a little bit more esoteric, which is legally where the fun comes in, right? And OAR 660-033-00201A and the statewide planning goal follow the same frame here. The second thing we look at is what's called other lands. And the way those are broken down is they're saying if there are other lands which are suitable for farm use, they need to take that into consideration. The first thing they look at is soil fertility. We do not have soil fertility here. We have class 7 and 8 soils. We can set that one aside. Second issue is suitability for grazing. They tried that too. And if you take a look at an affidavit that was submitted into the record some time ago, Exhibit 25, I can tell you when it was submitted, on 11/23/22. Exhibit 25 was submitted, and that was submitted by the Fergusons, who entered into a contract with the owner of the property to irrigate the property and graze it for a summer. And it went so badly that they quit after 2 months. They couldn't get the soil to hold the water. They couldn't get anything to grow. And the conclusion in the affidavit from the Fergusons is they could get 1 or 2 head of cattle to be sustained on the property with irrigation, which makes no sense. So the suitability for grazing is dealt with here, and I think is reasonably eliminated from consideration. The next issue that they ask you to consider is climatic conditions. And for those of us who live here in Central Oregon, we know that we're lucky if we get a 60-day growing period between frosts, which means the ability to grow anything that requires frost-free is not going to work. We've had snow on the 4th of July. We've had heavy winds. This is not an area for any kind of a tender crop. The things that tend to grow here are things like alfalfa. And that's what, Ferguson was trying to do that, and that didn't work either. So climatic conditions are such that we're severely restricted. Grass is one of the only things that grows, and even that wasn't able to be done here. Next is the existing and future availability of water for farm irrigation purposes. And this happens to be a location that has irrigation water available to it, but it doesn't work. The irrigation line runs along the eastern edge of the property. There is an area that's somewhat flat and kind of sunken that has even attempted to be used as a pond before. They really have tried to make this work. And so there is water available in the area, and there may continue to be. However, here in Central Oregon, we're going through a significant period of readjustment on how we use our water, how we allocate water, how we prioritize it. The irrigation districts are being severely curtailed in terms of the supplies they have. So where before here in the county, you might have been able to flood an area pretty deeply and get something to grow. Now you're sprinkling instead, and it dries up before it gets a chance to propagate. So existing and future availability of water for farm irrigation purposes, it's there, but it doesn't work because when they've tried to irrigate it, it hasn't allowed growth sufficient to sustain cattle. The next issue is existing land use patterns. And in this case, that's where the 1 mile packet comes in. So what I'd like you to do is take a look at Exhibit 37, and I'll walk you through it in kind of a general way. Now, some of the things in this packet are not going to be appropriate to this, but I included them because this is a form system that the county has. They can generate it fairly quickly. Caroline did so, and I really appreciated it. And it tells us a lot of what we need to know. If you take a look at page 2 of it, what it tells you, it shows you where the land use application is, and it shows you where the farmlands are around it. And the first thing you notice is that exclusive farm zoning is predominantly to the west of the subject property. There is none to the south, there is none to the east, and there is a little bit to the north, but it's not in farm deferral. On page 3, you can see what the soils are. And again, the soils on the subject property are not that different from the soils surrounding it until you get over the river and look to the west of the subject property, where you get to some richer soils. And that is documented in the actual uses, as we'll see going forward. On page 4, you see the tax deferral. And the closest tax deferral parcel is the 17.35 acre parcel over the ravine, over the river, on the other side of the mining pit. And that property is 17.35 acres. And that's how far away it is from the subject property, in a completely different class of soil, and also not available by vehicle between the subject property and the property on the other side. There's no bridge in that immediate area. There's no way to cross it. Page 5 shows total acres, and you can see that the area is pretty well broken up. There isn't a lot of what we think of as 23+ acre property that's being used for farming in the area. That's not what we have there. It's already gone through a change. Page 6 shows you the year things were built. I don't think that's directly pertinent, but it's there if you're interested. It gives you a sense of the pattern of development through the site. The last conditional use permit, I also don't think is relevant on page 7. Page 8 includes an administrative determination permit. Again, I don't think that's relevant. Page 9, however, I think is. That's an aerial photograph that came from 1985. And what it shows is the history of the property in the area not being very heavily developed. There's not a lot going on there in terms of farmability. There's a lot more farming on the other side of the ravine. Page 10. Page 10 is an excellent depiction of what the property really looks like in terms of what NRCS sees. It is essentially barren. There is not much going on. You can see a place where there was the pond over on the far east side, where they tried to set up a pond. It is lined to hold water. They did everything they could to try to make it work, but it wasn't feasible, as the Ferguson affidavit shows. The next one that I think is interesting is, no, I think that's it. That's the only thing that I thought was really pertinent to this. But as you can see, it shows clearly that the nearest farming to the subject property is quite some distance away. And so the next exhibit I would like you to look at is Exhibit 38. And Exhibit 38 is a dial diagram that shows the distance between the subject property to the nearest farm deferral parcel, and it's approximately 1,600 feet on the other side of the ravine. That's not close. It's not adjoining, and it's not adjacent. All right. Ooh, 6 minutes. Okay. So the goal 5 issue, let's talk about that one next briefly. Here's how that one works. OAR 660-015-00005 says that the goal 5 purpose is to protect natural resources and conserve scenic and historic areas and open spaces. Relevant here are the following features: riparian corridors, state scenic waterways, approved Oregon recreation trails. Those are mandatory to be inventoried. And we do have a state scenic waterway in the Deschutes River, though it's not navigable all the way down. There is a riparian corridor, and there is also an approved Oregon recreation trail down along the river that the Cochrans dedicated to state parks as part of a negotiation back in 2017 and 2018. And that was as a result of us doing an early title analysis of the subject property and determining that the existing trail that was down there was so poorly described that it was possibly not even legally enforceable, which is very general. It was written in the 1950s and nobody surveyed anything, and they just kind of said, well, it's down there somewhere, and it didn't work. So what we did is we worked with OPRD. They had a survey done. We dedicated a specific trail down there, and that connects the Tumalo Park to Riley Ranch. It's an important trail, and it runs down there along the river. The 2 areas that are encouraged to inventory that are also potentially factors here are the open space and the scenic views and sites. What we would suggest here is that we go to the rules that were set out in the Central Oregon Land Watch versus Deschutes County and LB&W LLC case, which came down as 2023-008. What that case said was that if you have a Goal 5 resource and it is affected by a potential post-acknowledgement plan amendment, then you have a responsibility to look at the possible uses that could conflict with that resource because the resource takes priority and has to be protected. In this case, the Goal 5 resource that we are most concerned about is the river. But in addition to that, the mining site, which is it's designated as the Pink Pit, that is over on the west side. It is not currently active. It hasn't been for some time. It's been the subject of extensive litigation where neighbors tried to keep it from continuing to be developed, but it is technically still open. It has not been reclaimed, and it still exists. So this application is within the landscape management zone of both the river and the surface mine impact area. And that is something that we will be addressing in this open record period in much more detail at that time. In general, taking a look at the kind of uses that are permitted in farm versus in MUA 10, I think it's interesting to note that the uses allowed in farm aren't a picnic. I mean, there's some pretty tough stuff in there. Mining obviously is one of them. Utility lines are another. And these are just the outright uses. An on-site sewage treatment plant, outdoor mass gatherings, composting, There's all sorts of stuff allowed there that wouldn't be compatible with a nice float down the river. And those are just the outright uses. The conditional uses are things like a disposal site, a golf course, a compost mecca, essentially, with barns and sales and development, fishing preserves. Those are all things that are allowed in EFU. Also, agritourism would be allowed in that location. And this wouldn't be a type 3 agritourism. This would be a type 2 agritourism site, but that would be a significant site. Just that's what's allowed now on EFU. Comparing that to the MUA 10, what we find is still agricultural uses, because multi-use agricultural is a quasi-agricultural use. It's just acknowledging the fact that it's not going to be for profit. It allows horse events. It allows a dude ranch. It allows a kennel or a vet clinic. It allows a landing strip. It allows golf. It allows PUDs and clusters. It allows a hydroelectric facility. And it allows bed and breakfast, things like that. So those are all things that we will be analyzing in detail to discuss whether those could be conflicting, because that's what's essential. All right, in summary, the application that you have before you is complex because it has evolved. The floodplain has been removed and sold to the adjoining property owner on the west side of the river. So there is no floodplain anymore on the subject property. A lot line adjustment made that happen. And in addition to that, the lot of record has been verified with that change. So we have both of those big issues resolved. And I know those were of concern to Central Oregon Land Watch, and I understood why they were, but that has been resolved now. The application that you have in front of you is a classic example of accommodating what's coming. The urban area reserve is literally right on the south property line. The UGB is about 2,000 feet to the south and a little bit to the east. The city of Bend, obviously, when they do an urban growth boundary expansion, they pop into exception lands, and that's what this is. We ask that this application be considered with that in mind. Thank you.
Thank you, ma'am. Just to make sure for the balance of the hearing that we're on the same wavelength. Early in the staff report, it indicated that there was originally an application that you referenced at least lot sizes and similar issues with ultimate development of the property. That's not on the table tonight, as I understand. Is that correct?
That is correct, but it was in the staff report, and I felt that it was important to resolve it because it was in the staff report.
Not a criticism. I want to make sure that as we go through this hearing, I noted in the staff report that there was a number of issues raised that appeared to me to be very appropriate for a site plan review, but perhaps not so important here. And I'm just cautioning folks that follow you that I will be making the same comment to them as well, is that relevant approval criteria may not include some of the things that really seem important to either you or the other folks maybe in opposition. So I just want to clarify as we go through this, keep in mind what we're trying to do with this application and not any future application.
Understood.
Okay, thank you. Since the record is going to remain open, and we'll talk about the logistics of that at the end of the hearing, I leave it up to you because you're in control of the applicant side of things. If you wish to have any additional consultants talk to me at this point in time, that's great. If not, please keep in mind that the record will remain open. And I'm inclined, since there is no clock here on this one, at least as I understand it, and I will stand corrected, that I'm probably inclined to do your 2-week initial open record period unless I hear something negative from someone else who testifies or staff. So there will be an opportunity for clarification, as I indicated in my opening comments. I do tend to read things. I don't know about you or anyone else in the audience, but when you read something, you have an opportunity to reread it if you don't understand it. If somebody talks about it in testimony, sometimes you don't go back and get a full understanding because you might have not understood it perfectly. So with that in mind, do you have any additional folks you'd like to have testify this evening?
Tim and Joe are here tonight as resources. If an issue comes up that is helpful, they are available to answer questions.
Cool. And keep in mind that you do have a rebuttal period. So if you'd like to bring them up to respond to something that came up in testimony earlier, you certainly have the right to do that. Okay.
Thank you.
All right. Anyone else speaking on behalf of the applicant this evening? Ms. House, if you can help me out here.
I do not believe so, but I'll defer to Ms. Dixon on that. I think you're done with your testimony.
We are.
Okay. Is there anyone else who wishes to speak on behalf of the applicant that is not on the applicant's team?
I don't see any raised hands.
Okay, so that takes care of that. Would anyone like to testify in opposition? And if you're in person, let Ms. House know because she's there. If you're online, please raise your hand. I didn't make Ms. Dixon do it, but I'm going to do it for everyone else. Please spell your first and last name when you testify, as well as give your address. I have Ms. Dixon's spelling of her name and documents that I reviewed shortly ago. So anyone in opposition?
Yes, there's one person in attendance that would like to testify.
Please have them come forward. And when we're ready, first and last name, spell your first and last name and address, please.
Good evening, hearings officer, and my name is Carol Macbeth, and I'm a staff attorney for Central Oregon Land Watch. Our address in Bend is 2843 Northwest Lolo Drive. We do have several comments in opposition to this application. One of them is that it sounds as though the applicant is preparing to submit application materials on Goal 5, which we have not seen. The steps in this process are that an application is prepared, it's deemed complete, then a staff report is prepared 7 days in advance of a hearing. This hearing is supposed to be on the application. It's not like an ongoing thing. I mean, it's very difficult to even see what the application is in the record now, let alone with more things being added at every moment. We ask that the hearings officer tell us when the application was deemed complete, not necessarily tonight, but soon, and that once it has been deemed complete, then we could start with the hearing, and then we could have an open record period, a rebuttal period, and a final argument. But Land Watch cannot be expected to continue to respond to an ever-evolving application. We can make up comments, find that the application has changed, and make up new comments. And that's an untenable process, and it violates our substantive rights to a hearing that's conducted in accordance with the state of Oregon's and Deschutes County's hearing procedures. On Goal 3, we disagree with the applicant. A Goal 3 application exception is required because this land is agricultural land. The applicant's own evidence shows that this property has been used for the grazing of livestock. There is a horse grazing on the property now, according to neighbors, and it has also been used for irrigated crop production, according to the applicant's own materials. Land that has been put to farm use can be put to farm use, which is the question before the hearings officer. No reasonable person could find that land that has already been in farm use is not suitable for farm use or cannot be put to farm use. It's illogical, and it wouldn't hold up to judicial review. So because it has already been put to farm use, there's little question that it is able to be put to farm use, and it is agricultural land as a matter of law. We explain this in our written materials. The definition of agricultural use land in Oregon is extremely broad, and it encompasses many, many rural lands. The legislature's goal was to not just protect land that someone may think they can farm, but land that others could farm, and lands that may not have soil suitable for all uses, but are suitable for many uses, like grapes or poultry or pigs or hogs or horses or horseback riding lessons, All of these things are farm uses. The definition is so very broad that it is very difficult to find land that doesn't qualify, and this land is not among that set of lands. This land is suitable for farm use, and it does qualify under the applicable law, as we explained in our written comments. And Goal 14 also requires that land outside an urban growth boundary cannot have an urban density. What is being proposed is an urban density. 1.75 acres lots are an urban density, and so is 1.70. Whichever it is, that's an urban density. And no urban densities can be developed outside of UGB without an exception to Goal 14. Goal 14 exceptions, according to the Supreme Court, must show that all rural uses are impracticable on the subject property. That cannot be shown. This land could be used for many uses, including the livestock uses it's already been put to, for the irrigated crops it's already been put to, or for other irrigated crops or other animals or crops that don't require any particular soil. And so a Goal 14 exception is also required. Because neither a Goal 3 exception nor a Goal 14 exception has been applied for, it can't be, this application has to be denied. And if they did try to qualify for a Goal 3 exception or a Goal 14 exception, they won't qualify. And thank you for taking that. We agree with Ms. Dixon's request for keeping the open record period, although we are concerned that the open record period may change depending on when this application is deemed complete. I would also like to ask for clarification that the clock has been suspended. We don't want to run into an 150-day clock problem. Thank you.
The only one I'm going to respond to tonight, because I understand your testimony, is the clock issue. And I do not believe, and I'll ask staff just to confirm, but it's my understanding in this particular application that there is no 150-day clock because of the comprehensive plan request. So if I'm wrong, certainly you'll let me know. But that's my understanding. And I'd ask staff to respond to that.
Okay.
Yeah, so Deschutes County Code DCC 2220-040D specifically says that the 150-day clock is not subject to comprehensive plan amendments are not subject to the 150-day clock.
So because they've separated these two, then it doesn't apply.
So it's the county's position that any email correspondence related to the 150-day clock is only specific to the tentative plan and conditional use requests for the plan unit development. Okay. So it's not applicable to this particular these applications and the modification to the extent that's relevant.
Great, thank you.
Thank you, Ms. Macbeth. Anyone else in opposition?
There's no one else attending in person, and everyone else attending online is with the applicant's team or is county staff.
That makes things simpler. All right. Does the applicant have any final rebuttal that they wish to add at this time?
Just a second here for the transition.
Okay, so I'm sorry.
Yeah, no. Looks like Ms. Dixon was just promoted.
All right.
There, I'm back. Okay.
Don't you love the terminology being promoted? It's always, every time I get promoted in this to a panelist, I'm always very thankful, I guess. I don't know. Go ahead.
Gratitude's a wonderful thing.
Yes.
All right. In response to Carol's comments, I will happily reply to them in the submittal during the open record period, rather than try to get involved in the details of it now. I understand her concern about the evolution of the application. She and I have talked about it before. Yeah, I understand that it's frustrating for them. We'll do the best we can to be clear and give her plenty of time to get her comments in so that we can get a decision that everybody feels was properly aired. And that's it.
Thank you. Staff, any final comments?
No, I was just going to clarify the 150-day discussion. And then just for clarification on the record, just acknowledging a lot of the materials that the applicant has submitted or under their application materials category on the website. There's the application materials supplemental, and then some of the applicant's exhibits specifically that they reference at tonight's hearing are in their incomplete letter response. So that would be the next category down below application material supplemental, you'll find their incomplete letter response there, and you'll find additional exhibits that are referenced in the applicant's material. So just clarifying that for all parties involved.
Thank you. Go
Hearings
ahead.
Officer Frank, there's a request in the room from Carol Macbeth to respond to, I guess, that to clarify or ask a question regarding the record.
Have her come on up and promote her as well.
Okay. Thank you for promoting me. This is Carol Macbeth again, for the record, from Central Oregon Land Watch. I just wanted to seek clarification. We said that we don't know what the application is, and the staff just noted about 5 different places that we're supposed to look to find the application. We want something that's called the applicant's materials that should be all in one place. We don't know when we've seen what the applicant has submitted, so we can't respond to it all. There's a map here, and there's some sort of modification here, and some things have the title at the beginning, but you have to read down 11 pages before you see that it's actually an application for 2 different things that the title did not explain. And I'm just concerned that we are going to miss things in the application, and that it isn't part of the applicable procedures for us to have to search through. There must be over 100 items on the list for this particular property of development proposals that have ever been put in, and we can't be expected to go through them one by one, look through them all. Some of them are hundreds of pages, and make sure that each one of them is not something else that we've already seen. So we ask to have something in the counties, where a place for us to go to look at what is the application and what is not, so that we can respond to it, and especially within the time limits that will be set for this, for open record and rebuttal. Thank you.
Thank you, Ms. Macbeth. Ms. House, any response?
Well, what I can state is that anything received during the open record period will be grouped into 3 different categories. So there'll be new evidence and testimony, rebuttal evidence and testimony, and the applicant's final legal argument. So moving forward, there'll be no changes in how the record's been presented to date, other than what I just described. And that should be easy to track because it will be in that order and displayed on our website. We do have some technology limitations, but at the same time, all the information is presented on the website. So all parties have equal access, and the hearings officer and anyone interested has the same access to the information. And I guess if someone has questions, they can always reach out to me, and to the extent I can clarify where something is located, I'm happy to do that as well.
Okay, thank you for your comments. The only other question that was raised that I'd like staff's response to was the date the application was deemed complete. And it doesn't have to be answered on the record, but if you have that handy, it would be just if you could let Ms. Macbeth know that on the record, if possible.
So this particular application, because it was at one point in time being processed at the same time as the tentative plan and conditional use request for the plan unit development, I think that probably created the confusion. I don't think the county deemed this application complete per se, but to the extent the county has additional information to add, we'll respond during the open record period. Again, the county code specifically states that this request, this plan amendment zone change request, is not subject to the 150-day clock. So to the extent there's anything else to add, I'll supplement the record during the open record period.
Excellent, thank you. The last question I have of you before I turn it back over to have a discussion with the applicant's attorney is any suggestions, concerns regarding the open record period, suggestions?
No requests from staff. Thank you for confirming. No.
Okay, and any limitations? Let's presume that as hearings officer, I do what I've been known to do on occasion and say, well, let's try this out. And if I would happen to do that, I would probably suggest perhaps instead of a 2-week period, a 3-week period. And I'm making this up as I go. I'm not. There's no science to this. I'm just trying to draw a reaction from staff. So if I said 3 weeks, 4 weeks, and a 2-week responsive open record period followed by the 1-week final argument period for applicant, any concerns or comments or suggestions regarding making any one or all of the periods longer?
The county can accommodate however long that you feel is reasonable for this particular review. The only thing that staff would add is, if you wanted to shorten it down to less than a week, we would need to look further into the code. But no, at 3-4 weeks, we've accommodated that without any issues in the past. So I don't see a reason why we couldn't do this case.
All right. Then, Mr. I'd ask that the applicant's attorney, if you can elevate her, promote her, whatever it is, so we can talk ever so briefly.
I'm back.
Hey, welcome back. Ms. Dixon, and my comments are not just for your benefit, they're for Ms. Macbeth's comment, Ms. Macbeth and Ms. House's consumption as well, and anyone else listening. I have another decision I'm working on right now, and it relates to many of the same issues that we have here today. Right? And as part of that, getting ready to come up with a decision in that case, I spent about 2.5 hours today reviewing the most recent 85-page Land Watch LUBA decision that you referenced. And quite honestly, and this is only my opinion, but it is a challenging opinion to read. The concepts followed by the Land Use Board of Appeal or the positions they've taken in some cases seem interesting. Let's put it that way. But what I came away from that probably 3 or 4 hours ago is this whole subject area is really challenging. It is a challenge to put all of the words or phrases together, the agricultural use and the farm use and dealing with Title 18, 16, whatever it happens to be related to these things. And is it exactly the same or different than the OAR sections or even the statutory sections? So I find it to be a really challenging area. And it seems to me that I have no clue whether or not that particular LUBA decision is being appealed, but it certainly isn't going to see resolution from the Court of Appeals if it was for a while. So we're not going to get any clarification, I don't think, for some period of time. It seems to me that the Land Use Board of Appeals has set a pretty high standard, particularly with uses in conjunction with adjacent or nearby properties, the issues that kind of surround that. So I'm wondering, is the 2 weeks going to be enough for you to be able to adequately assess that? I mean, I think it's going to take me another 2 weeks to actually understand that opinion, quite honestly. But I'm doing my best. I don't want to shortchange you, and I don't want to shortchange Central Oregon Land Watch having an opportunity to review your input. So let's go back to your 2 weeks and 1 week and 1 week. Do you think that's adequate? And are we going to get a reasonable decision? And that doesn't even include the issue about the procedural issues raised by Ms. Macbeth tonight. And I'm not saying that's hard, but it is an issue that needs to be addressed. So what can you tell me?
Well, I felt like I was being a little greedy asking for 2 weeks. But at the
You're
same
not.
time, okay. But at the same time, the time that I have spent with these cases, I agree with you. This is an area of the law that is at best flexible at this point, I think.
It's a very generous way to talk about it.
If you're comfortable giving me 3 weeks for the open record, I'll take it.
Okay. Yeah. I'm comfortable with whatever time that we get the information into the record that's adequate to allow me to make a good decision. Bad information and bad evidence, bad arguments of the law make my decision bad, almost by definition. And the better the information from both you and Ms. Macbeth and anyone else who submits information to the record, whoever submits it, the better information I get, the better argument I get, the more likely it is I can actually have a decent decision. So I'm open to your suggestion, is what I'm trying to tell you.
All right. I would suggest we leave the record open for 3 weeks. We do the rebuttal record for 1 week, and we do the final argument for 1 week.
And I've already asked staff, and they don't seem to be objecting to that. So staff, would you give me, math is not my highlight and counting days on a calendar is not my strength. So you want to give me a 3 week, 1 week and 1 week time frame that works, that is actually right?
Yeah. So I have, so for new evidence and testimony with 3 weeks from today, that would end on Tuesday, March 19th at 4 p.m., followed by a 1 week rebuttal period. That would end on March 26th at 4 p.m. And then final legal argument for the applicant would end on April 2nd at 4 p.m. And that's 1 week from the end of the rebuttal period, if I didn't say that already.
So what I'm going to turn it back over to Ms. House in just a sec. She's going to talk about the logistics and that kind of thing. But what I'm telling you is that the open record period will extend for a period until 4 p.m. on March 19th, 2024 for new evidence. It will extend until 4 p.m. on March 26th for responsive evidence. And finally, on April 2nd at 4 p.m. for applicant and applicant only's rebuttal period. So those are the time frames. I'm going to just give one caution, is that anyone who wishes to desires to submit information, evidence in the record, argument in the record, up to including 4 p.m. on the 19th, that's the first period, may do so. I beseech you, because there often are consequences to this, but I beseech you that between the 19th of March and the 26th of March at 4 p.m., that there is only evidence in response to what was submitted on or before the 19th, so that during the first open record period, so that 3 week period. I beseech you to do that. I ask you to do that because it avoids me having to make procedural decisions that somebody went far afield and offered something for the very first time during that second open record period. And finally, the only response that I will get that is due during the third period of time, which ends on the 2nd at 4 p.m. of April, is the applicant. Only the applicant has the right to submit final argument. And I always raise this caution. It's not any reflection on Ms. Dixon or anyone else. It's final argument. It's no new evidence. And please do not put me in a position of having to get in a position of deciding if something is new evidence or final argument. Stick with your argument. You've got a nice long period of time to deal with this. So, Ms. House, you want to talk about how we get this stuff in?
Yeah. So just up on the screen again for the recording, if you look back at this, these dates are published, and I'll make sure this information is also on the website. So electronic submittals must be received by the county server by 5 p.m. on the date of the deadline shown on the screen here. And if you're going to email me materials or drop off materials, they need to be to my attention. I will put them into the record for the hearings officer's consideration, and hearings officer Frank will be notified at the close of the record once everything is uploaded. So he is looking at a complete record before starting or finishing his review, I guess. Electronic submittals need to be emailed to me directly. My email is caroline.house@deschutes.org. It's also important to note that the county does not retrieve any information from a website link or from a cloud storage software, so like Dropbox, that kind of thing, for security reasons. So if you want that evidence in the record for the hearings officer's consideration, you need to actually present that information, download it, and provide it as a PDF. And again, the deadline is 4 p.m. For the county server. So large files sometimes take a long time to come through. So I highly recommend not waiting to the last minute because we are going to rely on when that information hit the county server for entering that into the record. And then it would be up to the hearings officer to, again, go over the procedural question of whether we received all of your information timely. So that covers everything I was planning to cover, Hearings Officer Frank.
Thank you, Ms. House. This is one of the few times I ask if anybody has a comment or question about what I said, dates. So that is the 19th, the 26th, and April 2nd, those dates. So if you have a question about those dates or the time something's due or how you get something in, I would ask that you bring that up right now from a procedural perspective.
And there are no questions.
Okay, thank you. Then what I'd like to say now is I appreciate everyone's testimony. I appreciate everyone's comments. I look forward to a vigorous set of submissions in this case, because I think this is one of those cases where they could actually be beneficial both to the county, myself, and anyone who is interested in this particular topic. So with that, then we will close the oral portion of the hearing, and the record will remain open as stated. Thank you so much for coming, and thank you so much for your testimony. I wish you a good evening.